We fulfill our obligation, our public interest obligation, in a number of different ways. Some of us work full-time in the nonprofit world or for government. Some of us do pro bono work on behalf of underrepresented groups. Some of us work to further law reform. And some of us serve in appointed positions in government. Thomas Perez is a stellar example of a life well lived in legal public service. He has, in a variety of positions, served the public interest, including the following. He was a federal prosecutor for the Civil Rights Division of the Department of Justice, the chair of the Federal Interagency Worker Exploitation Task Force, special counsel to Senator Kennedy, director of the Office of Civil Rights at the United States Department of Health and Human Services, secretary of the State of Maryland's Department of Labor Licensing and Regulation, and also, of course, teaching in the clinical and health law programs at the University of Maryland School of Law. In October 2009, Mr. Perez was confirmed by the Senate as the Assistant Attorney General for the Civil Rights Division. In his own words, he said, quote, "The Civil Rights Division is the conscience of our country, enforcing laws designed to give meaning to the enduring promise of equal opportunity and equal justice under law." So today I look forward to hearing him discuss why he believes, in the words of Senator Kennedy, that, quote, "civil rights remains the unfinished business of America." And I would like to ask the Assistant Secretary to join us up here, and following this talk, he will answer questions, and then we'll have a reception out, an informal reception outside the room. Thank
Great.
you.
Thank you, Dean.
Thank you.
Great to be here. Can you all hear me? Great. I think the answer is no. I don't need a microphone. It's great to be here. I was looking at the ranks of our front office staff in the Civil Rights Division. We have 5 Deputy Assistant Attorneys General for Civil Rights. 2 of them are graduates of the University of Chicago Law School. So you have quite a market, one of whom is in your corner there. His name is Roy Austin. Class of 77, Roy? 78. Something like that. May have been 78, 98, 94, something like that. We actually hired Roy as a summer clerk when I was a career prosecutor in the division, and Roy is one of your finest graduates, Dean, and we're excited to have him. I'd like to talk about 2 things, and then when I'm done, I want to take your questions, so I want to try and do my best to make sure we save time for that. And question number 1 is I'd like to talk about why we still need, in the year 2010, laws against discrimination. And then related to that question, I'd like to address the follow-up question of why we need a Civil Rights Division, aside from the fact that it provides employment to University of Chicago Law School graduates. A noble reason in and of itself, and I could stop right there, but I think I will go beyond that. When I taught at Maryland Law School, I used to do this Pavlovian exercise in my civil rights class where I would, at the beginning of the semester, write the word discrimination on the board and ask people to tell me what is in your mind. What's the first thing you think of? And people would talk about the things you would think they would talk about: Brown versus Board, the glass ceiling, police abuse, police misconduct, etc. And when you think about the civil rights movement, you think about places like Greensboro, places like Birmingham, where I was just at the Civil Rights Institute last week. We think about the remarkable sacrifice and courage of the Greensboro Four, the remarkable courage of Rosa Parks, and we think about the change that courage brought about so that we could enjoy places of public accommodation free of discrimination. We could go to a swim club free of discrimination. You could sit on the bus. You could go to school and think about equal educational opportunity. And those concepts have become, I think, generally non-controversial ideas, And the vast majority of Americans agree with these concepts and agree that that movement was a courageous movement that brought about a lot of good. But what I've learned since I've also come on the job last October is that there are a number of people of good faith who believe now that with the election of an African-American president and the ascension of a Latina on the Supreme Court, a woman Speaker of the House, that we have reached what some call post-racial America, where laws against discrimination, well-intended though they may be, are frankly no longer necessary. And they believe, in good faith, I have no doubt, that these great accomplishments, and they are undeniably great, and it must have been a remarkable experience on election night to have been up the road in the park here. I only got to witness it on television, but I can't imagine what it must have been like. There are those great accomplishments, and they are indeed evidence of the remarkable progress we have made as a nation. And so there are remarkably accomplished and respected scholars who believe that these laws against discrimination, again, while well-meaning, are really now representation of a heavy-handed government, and these laws really inhibit the free market. Now, it may not shock you to learn that I may not agree with that position, and not simply because I have this job and I'd like to keep this job, but because I have a rather lengthy experience in this area. In 2010, we live in a remarkably small world, and the global economy is allowing companies large and small to expand into diverse marketplaces. In almost any workforce that you go into, whether it's Coca-Cola, a large Fortune 500, or a startup nonprofit that wants to get into the biotech world, expand into foreign markets, it is critically important for that workforce to be culturally competent, to be citizens of the world. You look at the Grutter case in 2004, and that was a case in which the most number of amicus briefs in the history of a Supreme Court case were generated. And who wrote the lion's share of those amicus briefs? Fortune 500 companies, talking about the economic self-interest importance of having a diverse workforce and the economic self-interest justification and rationale for having diverse student bodies in campuses. And they talked about how it is not simply a moral and ethical imperative, but it is an imperative for their bottom line. It is in their economic self-interests. And in a global economy, it is indeed, I believe, very accurate that a culturally competent workforce for many companies, large and small, is again not some misguided social engineering. It is about a company's enlightened economic self-interest. Now, the immediate response by those who do champion the free market is often that if diversity is indeed a necessity for business success, companies will take it upon themselves to increase workforce diversity in order to compete. And that, in turn, if it were true and functioning, would make anti-discrimination laws irrelevant. And I must confess, I would like nothing more than to see no need for anti-discrimination laws. When I was a kid, there was a commercial on television for Maytag, and there was this guy, the Maytag repairman, and the image of him sitting by the phone, falling asleep, because the phone never rang because Maytag products were made so well. I'd love to be that Maytag repairman, but I'm here to tell you that, frankly, in our division, we're more like the Toyota mechanic. Our phone rings with regularity, and that is the fact of life in the Civil Rights Division. And while many companies, large and small, have indeed worked hard and made real strides to increase diversity, there are indeed strong indicators that the playing field for all too many people is not level. Of the Fortune 500 companies, we have 15 female CEOs, 5 African American CEOs, 6 Latino CEOs. A study of Fortune 500 boards of directors released last year by the Executive Leadership Council found that the number of corporate board seats held by African Americans had actually declined since 2004. I was very intrigued by a recent set of interviews that Judge Posner gave, in which he said, and I quote, If you're worried that lions are eating too many zebras, you don't say to the lions, "You're eating too many zebras." You have to build a fence around the lions. They're not going to build it. His comments were made last year in reference to his evolving ideas about the need for regulation of the financial markets in the wake of our largest economic crisis since the Great Depression. But that concept applies here equally well. And if there's nothing else we've learned from the economic crisis, from the foreclosure crisis, from the banking crisis, we must walk away with knowledge that unfettered markets are not a formula, an automatic formula for growth, and that the markets will not automatically correct themselves, and that they require common sense government intervention. Because when you have humans running any operation, you will have human frailties and human failings involved in that operation. In the financial context, as someone who has worked on foreclosure prevention issues for the last 4 years, I have seen and learned that common sense consumer protection and preserving a safe and sound lending climate and a safe and sound banking climate, they go hand in hand. They are not at cross purposes. Quite the contrary. They are inextricably intertwined, and we have seen all too much evidence of that in the context of our failure to have adequate consumer protections in place. There was a recent article that Susan Estridge, when I was at Harvard, she was a professor there, and she wrote about the tech giant Apple, and she talked about the fact that none of their leadership positions are held by women. And when contemplating why the global company like Apple, with a reputation of its remarkable nature, would have no women around the table, she wrote, and I quote, "I am absolutely certain that no one at Apple sat down and decided that women should be excluded from all top positions. My guess is that the issue just never came up. It's just that when they think about who the most qualified person is, they think of someone just like themselves. And when they're sitting in a room full of people who look just like them, it doesn't occur to them that someone is missing." And that's a lot about what discrimination looks like in the year 2010. It is frequently not blatant, and it is often not intentional. Yet it continues to hinder our progress toward true economic opportunity and our progress toward economic efficiency. It is the reason why so many people of color, for instance, have been impacted in the foreclosure crisis. Housing discrimination and lending discrimination are what I often call discrimination with a smile, because the victims, all too frequently, have no idea that they have been a victim of discrimination. They think that they have just realized the American dream of home ownership. Little did they know that that 10% loan could have been a 6% loan, because that's what they qualified for. But they were gouged in the context and in the process of home ownership. And that is why I spent the day with Lisa Madigan, the Attorney General in Illinois, touring communities that have been torn apart by lending discrimination, learning again and again that once again the problem of foreclosures is a problem that touches every community, but it's a problem, the evidence shows rather clearly, disproportionately touches communities of color. And laws against discrimination protect and ensure that level playing field and ensure and protect the economic efficiency and functioning of our economy. Dr. King wrote from his letter from the Birmingham jail, lamentably, it is a historical fact that privileged groups seldom give up their privileges voluntarily. Well, we've seen legal segregation and Jim Crow replaced by these more subtle forms of discrimination, but we have to address this institutional discrimination, these policies and practices that are keeping our nation from realizing its full potential and that are tearing apart communities. And that is why 50 years later, after the creation of our Civil Rights Division, the importance of enforcing these laws of discrimination have never been greater. And it's not simply the housing context in which we see the importance of discrimination protection or anti-discrimination protections. Let's look at the employment context as well. Recently, we challenged New York City's use of 2 written examinations for hiring entry-level firefighters, and we argued that these examinations had disparate impact on African American and Hispanic applicants. And it's important to look at the data. The city's population is about 1/4 African American and 1/4 Latino. In 2007, African American firefighters were 3.4% of the city's workforce. Latinos were 6.7% of the city's workforce, of the NYFD. And compare that to the police department, which has 18% African American police officers, 28% Latino. Look at Los Angeles, 14% African American firefighters, 30% Latino. Chicago, 20% African American, 9% Latino. Houston, 17% African American, 14% Latino. One person told me off the record, it's all about the club in New York City. When you're in the firefighters, it is a white man's club. That's what that person said. Now, this judge who was ruling on a motion for summary judgment, and this motion was ruled upon after the Riki decision of last summer in the Supreme Court, he granted summary judgment to the United States, not simply on the issue of disparate impact, but he found that the decades-long evidence of discrimination that we presented to the court constituted evidence of intentional discrimination, and he granted summary judgment to the United States in that particular case, not only on the impact evidence, but on evidence on an intentional discrimination theory as well. So while we see, and there may be some folks who say, that data is great, fine and dandy, but why do we care about a diverse corps of firefighters? What does it matter? They just go up a ladder and they get people out and they bring the baby out and they get the cat out of the tree. Why does it matter what they look like? Well, it's important to understand what the job is about, because climbing the ladder is about 3% of the job in the year 2010. It's the fire and rescue service. You're doing EMT work. You're doing arson investigations. You're interacting with communities. And it's so critically important, as we learned in the aftermath of the Rodney King case, that if you don't have a police force that is culturally competent and can interact with diverse communities, that is a recipe for inefficiency, and it's a recipe for riots. Similarly, in the fire and rescue context, we can have the best and the brightest and the most diverse. We've seen it in other cities. We see it in the New York Police Department. And yet we saw discrimination, and we continue to see discrimination there. So we see examples time and time again of why we need laws against discrimination, because we continue to see subtle and, frankly, at times, some not so subtle forms of discrimination that occur. And let me tell you about a few not so subtle forms of discrimination that continue to rear their ugly head. Literally yesterday, there was a sentencing in a case in South Carolina, a hate crimes case, involving an African American who was driving up the road, needed to use the facilities. He pulls off the road and he goes to use the facilities, and a father and son team of bigots attack him because of the color of his skin. And they pull out a chainsaw from the trunk of their car, and they ignite the chainsaw, and they attack him with the chainsaw. And when 2 white people come to his defense, they attack them too. They torch the car. This is America in the year 2009, and the sentencing in the year 2010. We still have some very blatant forms of discrimination. We just settled an education case in Louisiana, in which there was a school district that was 87% African American. There were 2 high schools. One was 100% African American. One was 57% African American, 43% white. And in that latter school, there were 70 gifted and talented offerings and honors courses. In the African American school, the 100% African American school, there were 5 gifted and talented offerings. If we are going to build a global economy build a workforce that can compete in a global economy, we must ensure equal educational opportunity. That is not equal educational opportunity. And we had a similar case in Louisiana, or in Mississippi, I should say, involving a school district in which, through their transfer policy, the school district was allowing white students in one area to go to what was colloquially known as the all-white school. They were reestablishing a dual school system, a white school and a black school. And when we attempted to settle the case, the school board said, pound sand. They rejected our proposal, and we had to go to a judge, and he had to enforce a 1970 consent decree. Actually, it wasn't even a consent decree because they fought it back then. It was a court order of school desegregation. The other case I mentioned, that was a 1965 consent decree that we had to follow up on. And so we see time and time again discrimination in subtle forms, discrimination in not so subtle forms, in quite blatant forms. And these things absolutely undermine communities. They undermine the efficient functioning of our economy, and they impede our capacity to compete in a global economy because the playing field is not level for so many people. And that is why we need laws against discrimination. And that's why, quite frankly, in addition to employing University of Chicago graduates, and Tom Perez parenthetically, that we need a civil rights division. Because we have so much injustice that persists across America. We continue to see people with disabilities who are left in the shadows of our communities. We have so many people with disabilities across this country that are being warehoused in institutions when they could be living and thriving in community-based settings that are not only more humane, but are far cheaper than institutional settings. And one of the states in the United States that has the largest and most concerning institutional biases is the state of Illinois. And that is why we have a robust docket of cases in which we have sent letters of findings to the state of Illinois regarding unlawful practices of unnecessarily warehousing people with disabilities in state institutions and in private institutions when they can be functioning in community-based settings. And we have a robust docket of cases involving facilities that are frankly not safe. And what happens when facilities are not safe? People die. We had a case in Georgia involving a series of facilities in which there were people there who didn't need to be there. And those who were there were in unsafe conditions. And there was a 15-year-old girl whose memory, the death of her, is seared in my memory banks because she had some mental health issues. She could have been treated in the community, but she was in this institution. And she had treatment, psychotropic drugs, to treat her condition. And one of the symptoms, or one of the side effects of those drugs, was that she would become constipated. And she was in severe pain. But because she wasn't properly cared for, nobody asked her, what should be done about your severe pain? And she died because her bowels imploded. So when I talk about these issues, I'm talking about life and death issues that are in play because we do not have sufficient protections in place all too frequently across this country for people with disabilities. And so we continue to see that we have a continuing need in some of these legacy issues, cross burnings that occur, people who are attacked because of the color of their skin. We see people who are denied a job because they are gay. If I am a company trying to maximize my profits, I want to hire the people who are the most qualified people for the job. And yet, that doesn't happen. It happens to people who are gay. It happens to people who are Jewish. It happens to people who wear a headscarf. It happens to people who are women. And as long as we continue to have humans running human organizations, we will continue to to have discrimination, and we will continue, regrettably, to be that Toyota mechanic, whether it's in the employment context, whether it's in the voting context, or whether it's in the educational context. We have so much to do, and we have remarkably, and the good news story for me is that we have a president who understands that. We have an attorney general who has called the Civil Rights Division the crown jewel of the Department of Justice. And we have a remarkable cadre of career professionals who are doing remarkable work. If somebody ever says to you, issue X is a big deal to me, you should always ask them, show me your budget. Because budgets are moral documents. They reflect the values of a government. They reflect the values of a community. And this president has given us an unprecedented increase in resources. So we're hiring 100 new people in the Civil Rights Division, courtesy of Eric Holder, courtesy of President Obama, and courtesy of the U.S. Senate and the U.S. Congress. And that has enabled us to carry out our mission of restoration and transformation. And when we do that, we build, I think, a much more fair and just society, but we also build a much more efficient society. Because Judge Posner was not only correct in the context of the financial markets, he's correct in the context of the anti-discrimination context. Because we see it all too frequently, that discrimination creates an unlevel playing field. Discrimination creates barriers for so many people who want to be judged quite simply by the content of their character. I hope you guys are all going to graduate with a remarkable amount of opportunity. And I hope you will consider a career path like Roy Austin did. He could have gone to a lot of places, but he chose a career in public service. And I know that he's not getting the financial rewards that he might otherwise have been able to get, but as that commercial goes, the non-monetary rewards are indeed priceless. And if you choose a career path in public service, or if you go to a firm, I can tell you that the cases that we do, we often do in partnerships with big firms and small firms. You look at our voting rights history. So many of the most important voting rights cases we've done with cooperating attorneys across this country. Our case in New York, the New York firefighters case, we have private counsel who are representing plaintiff interveners, so we're in partnership with them. Our case down in Georgia involving the Georgia facilities, we're doing in partnership with some remarkable advocates. So there's so many different ways, shapes, and forms to begin with. And I'd like to close by giving you a homework assignment. I was going to say that at the outset, but I was afraid that some of you might get up and walk out because you're in the middle of your quarter, and the last thing you need is more homework. But it's an assignment I used to give to my students at the end of every term. And it was a good assignment. It was an assignment meant to provoke a little bit of self-reflection. And it's an assignment that I've done from time to time. And the assignment is this. I'd like you to write your own obituary. Now, it's a macabre-sounding exercise. But the intent of that exercise is to get you to reflect on a very basic question. Why are you here on the planet Earth? What is your purpose? And I have been very blessed in my life because I feel like I've been able to discover the answer to that question. And the answer for me has been to help underserved communities get equal opportunity, to build a society in which everybody can realize their highest and best uses of their talents. And so I feel very lucky in that I've been able to answer that. But don't wait until you're 60 years old to start answering that question and start addressing that question. Look at your personal statement when you came here, and then look at what you're doing now. I did a little exercise, Dean, at University of Maryland, and I asked the question, look at your personal statement. What did you say then? And we had the large number of people who used to say, I'm going to law school because I want to pursue a career in public interest law. And then I would fast forward and ask the question. We had X number of people who said that, and then I'd fast forward 3 years later, and we had X minus Y people who were actually doing it. And so we had that conversation about why is that the case? And there were many hypotheses. Finances, that's a legitimate issue. It's a lot of money that people get in debt. Some people change their mind. That's a legitimate issue. Some people just flat out lied on their application because they thought that's what we wanted to read. And they did a good job of it, so they got in. But I bring this up because it's really important. And I know you're in the middle of your semester, and this is such a remarkably intellectually rich environment. Sometimes you get a tendency to not have time to get off the dance floor and onto the balcony and ask that basic question. What am I doing here? Not just today, but tomorrow. And what am I going to do with this remarkable gift I am in the middle of being given? And I hope you'll spend some time reflecting on that. And if it's writing an obituary, to ask yourself what your legacy would be, do that. If it's reading your personal statement, then do that. If it's doing something else, sitting down with your favorite professor and talking to her, or talking to him, or talking to your dean, you should do that. But I hope you can find that answer to the question of why you were put on the planet Earth. And I think every lawyer who graduates, not only from here but from everywhere, has an obligation to get out there, and whether they're in the private sector, the public sector, whether they actually practice law or do something else, we all have an obligation to build a community that enables everybody to realize their highest and best uses. And so I hope you'll figure out how you can make that difference, whether it's helping somebody birth that micro enterprise, whether it's helping somebody in the healthcare setting, whatever it might be. There are so many ways to make a difference. And I'll tell you, and I've experienced this over 20 years, the non-monetary rewards are indeed priceless. They have been for me. They continue to be for me in a job that I believe is the best job that I could ever have, and it's a real privilege to serve. But we need more, because you know what? I got a bad knee. It's creaky. I got no hair left. I'm getting old, and I need to become irrelevant as soon as I can. That's my theory of leadership. It's the irrelevance theory of leadership. I want to become as irrelevant as possible as soon as possible. So I do smart things like hiring Roy Austin and other people who are really smart. And there's a lot of smart people in this room. And I hope you will take up that mantle and be tomorrow's leaders who are out there making a difference, building a global economy in which we can compete, because we do have that level playing field. So Dean, thanks for letting me spend some time. And we do have about 20 minutes or so to answer any questions y'all might have. I appreciate your time. Yes? Yes, sir.
As a former University of Maryland clinical professor, I wanted to ask you about the status and future of clinical education, especially as the state of Maryland itself and private interests have begun to encroach upon that law school's clinical program, and where you can see this going.
I'm very familiar. For those who are not familiar, there was an effort in the Maryland General Assembly that parenthetically is controlled in both houses by Democrats to take away funding from part of the clinic as a result of the clinic having had the audacity to stick up for people in an environmental context. And I think that's unconscionable. I think it's an encroachment. And I don't say this simply as a former law professor at the University of Maryland who happens to know the clinician really well. Put that issue aside. It's the principle. And it happens from time to time. It happened in Louisiana. I forgot if it was Xavier. I forgot which law school it was, but about 7 or 8 years ago, this happened there. About every 5 years, you see this issue rear its ugly head. And it's really unfortunate. And we all have to take, I think, a very principled position, because people are doing the right thing. People are getting punished because they are exposing wrongdoing. And you know what? I would say that if it doesn't matter if it's a cause that is a cause of the left or a cause of the right. That is not the principle that is the linchpin of what I am talking about. The principle that we need to uphold is when you have clinical education, you need to give people the latitude to do the work. That was not the finest hour in the Maryland General Assembly, and I have many, many close friends in the Maryland General Assembly and the Maryland Senate. But it was exceedingly disappointing to see how that unfolded. Yes, sir.
One of the difficulties of doing this work is that it seems like especially with regard to race, is that it seems like there's a running clock on how long constitutionally laws like affirmative action are running. How do we work within that what seems to be a shrinking window? It seems like this every new decision in the Supreme Court sets a time horizon for how long remedial measures will last.
Right. Well, Justice O'Connor, I believe, said, "I hope in 25 years that we will no longer need this." We're not waiting 25 years, and we don't take that decision as meaning we have 25 years to go. But we must continue to be rigorous in making the evidentiary case for the use of race-conscious remedies, and we must continue to be rigorous in, if appropriate, concluding that we have reached where we need to be. And that is why we are constantly, in the federal context, reviewing programs. And if the program, if there is not an empirical basis for the program, then you need to move on. I strongly supported President Clinton's "Mend it, don't end it." I wish I could say that we've reached that holy grail and we're in post-racial America. But we continue to see the empirical data demonstrating in many different contexts that there is, frankly, regrettably robust evidence base justifying the use of narrowly tailored race-conscious remedies. We have, in the voting context, a very rather specific admonition in the Supreme Court last year in the Northwest Austin case that we are ruling as we are ruling now because our jurisprudence says that we shouldn't reach constitutional issues if we don't have to, and there's a non-constitutional basis. But I can read, and I did read, and we understand that situation, and we have produced guidance for jurisdictions seeking bailout that conforms with the decision, and we will continue to do that. But again, I can also demonstrate for those covered jurisdictions in the Section 5 context that there continues to be a rather robust evidence base regarding the persistence of discrimination. And don't take my word for it. There are very few things that the Congress agrees on, but when the Voting Rights Act was reauthorized, it was unanimous in the Senate, and I think there were 4 votes against it in the House. How often does that happen, that Congress comes together around those issues? So your question is a great one, and it's incumbent on us to continue to ensure that we have the robust evidence base. And it's incumbent upon us to continue to do everything in our power to render these programs unnecessary. I would like nothing more than to reach that point where we can say that there's a level playing field for everyone. I'd like to see that happen tomorrow. That would be a remarkable America that we would live in. But those examples of Mississippi and Louisiana that I just gave you, those are 1970 and 1965 consent decrees. And here we are, 40 years later, 45 years later, still, it's like retro week at the Civil Rights Division, confronting vestiges of discrimination, the resegregation of school districts. And so the work continues. Yes?
Beyond segregation of school districts, it seems to me that one of perhaps the greatest civil rights issues of our time, our generation's time, is the achievement gap between white and minority students. And given sort of the empirical failure of assessment-based funding with No Child Left Behind, maybe this is beyond your office's purview, but can you explain how Race to the Top will do better? Or if not, what other changes you would like to see?
Well, the President and Secretary Duncan have proposed a robust series of reforms to No Child Left Behind that are intended to respond to a lot of the concerns about the teaching to the test and the fact that if you have an immigrant student who comes in grade 5 and makes remarkable progress, but then is given a test a year later and fails, that district might be a failure. And the No Child Left Behind revisions are intended to provide additional flexibility to address that. And so I think a lot has been learned over the course of the 10 years of No Child Left Behind. And a lot of changes need to be made, and that's what the President and Secretary Duncan are leading. Yes?
I'd like to ask a question about another critical civil rights issue of our era, which is mass incarceration. And I would like to ask what you think the role of advocates within the government and outside to change the degree of disparate racial impact of mass incarceration and maybe move away from that as a paradigm entirely.
We have the Attorney General convened a working group within the department, and we are actively involved in this to address disparities in sentencing. And I think ground zero for that issue is the crack powder disparities. And it's not the only battleground, but it is a remarkably important battleground. And the Senate recently, the Senate Judiciary Committee recently, actually the Senate actually got through the floor as well, passed a bill relating to reducing that disparity. And that's a disparity that obviously has remarkable impact in African American communities. And we spent a lot of time working on that issue in the Civil Rights Division because it is a civil rights issue. I mean, if we have a criminal justice system that is unfair and or has the perception of unfairness, then it's a system that cannot command respect. And so we have spent a fair amount of time working on issues of racial disparities in the criminal justice system, and it's a department-wide effort led by the Attorney General. We had a meeting of all the components that were involved in that about 2 months ago to bring together a lot of the thinking. So I was at a dinner the other night of the Constitution Project, which is a nonpartisan group, and the keynote speaker was Eric Holder. And the fact that Eric Holder is speaking at that conference, the fact that the president, the Department of Justice hosted an Access to Justice conference, and we had representatives of every state in the country there. And we had a robust dialogue about this. So we now have Professor Tribe leading an Access to Justice initiative within the government. So there is an acute attention being paid to a lot of these issues, and to the extent that your question involved, what do advocates do? I think continuing to provide the studies and the evidence base that can help inform our decision making, that's critically important. I mean, we had a foreclosure forum today up at the Fed here in Chicago, and you have a wonderful nonprofit, the Woodstock Institute, which does a lot of work in the lending context, and they provide a lot of the evidentiary heft that informs decision making, and there are many nonprofits like the Sentencing Project and others who provide that evidentiary heft that is equally important in the criminal justice context. Yes, Dean.
So you started out by talking a bit about the mortgage foreclosure problem and about being with Madigan earlier today.
Yes.
Also the Woodstock organization, which collects data on this. So I guess what I was wondering is, in your view, how much of the current problem is a civil rights issue, is a discrimination story? Because you have competing narratives here. I mean, certainly at the beginning of the mortgage problem was maybe 7-8 years ago. It was I think it was a race story. It was a predatory lending, victimizing communities of color. Then it morphed over time, and it's almost as if, certainly the critique from the right now is that it's the Community Reinvestment Act and its Fannie Mae housing goals, which encouraged banks to reduce the quality of the loans that they were willing to make, and I think that's empirically correct. But nonetheless, so the other side's making it's not a race issue, it's a regulation issue. And then when you saw, as the whole economy started falling in love with securitization and all the rest, it became not just an issue of race. I don't want to answer my own question, but it became a whole issue involving the middle class. And so I wonder, the way you framed it is a little broad for me, and I'm wondering whether you actually see it that way.
Well, there are, that's one of those $64,000 questions, or probably $64 billion we need to adjust for inflation. And I think the root causes are multifaceted. We're seeing a lot of just out-and-out fraud. We see a lot, this is that proverbial Venn diagram I'm about to do. We have predatory behavior, where people will gouge anyone, regardless of the color of their skin or their surname. We have discriminatory behavior, and I'm going to give you a specific example of a case. And some of the most ugly fraud that I've personally been involved in has been Hispanic on Hispanic. Se habla español. You get lured in because you have someone who's culturally competent. African American on African American. Come on in. And that's been some of the ugliest fraud we've seen. Discrimination, undeniably, and we have a mortgage fraud task force that has been established by the president and is headed up by Attorney General Holder. And we have a bunch of different working groups, one of which is a non-discrimination working group, which reflects our considered judgment that discrimination is undeniably one of the root problems. And let me give you a couple cases so I can give some context to it. We just settled a case with AIG, two subsidiaries of AIG. One was a broker, one was a bank. And the broker would lure people in, and you'd get the customer, and then they would give that customer over to the bank who would underwrite the loan. And what we found through our analysis, not just of HMDA data, but through some fairly sophisticated regression analysis, was that African American borrowers were getting gouged, that they were being charged exorbitant fees, that controlling for all other factors, other borrowers were not being charged. And so we reached a settlement in that case using disparate impact theory, which parenthetically was a theory that was verboten under the Bush administration. And the theory there was that, and the significance of the case is it involves relationships between brokers and lenders. Historically, lenders have claimed that brokers are independent contractors. They're free to go with any lender they want. We have no control over their behavior. You cannot hold us accountable. Well, what our investigation showed is that in this particular case, at least, and in many others, the broker, the lender, when they wanted to, had remarkable control over the broker. For instance, in the context of controlling what are called yield spread premiums, they had remarkable control because that affected how much money they could make. But in the fees context, they decided to put their head in the sand. And what's significant about this case is it sends a message to lenders that you are free to work with brokers, but you can't put your head in the sand and contend that there's no liability. We're also working on a host of other cases in the origination context. And I can't get too specific right now, other than to say that I'm rather confident that the evidence will show that controlling for all other factors, that African American borrowers and Latino borrowers were subjected to loans that were absolutely not the best loans they could have gotten given their specific profile, their specific lending profile. And the data, and again, I'm somewhat at a disadvantage, but I'm rather confident in saying that. Now, is that the only root cause? I certainly didn't mean to imply that, but I will say this. I spent a lot of time talking to people in my previous job who were 48 hours away from losing their home. And this is what I learned. People who are in the soup need four things. They need time, they need money, they need a good advocate, sometimes a lawyer, sometimes a housing counselor, sometimes somebody else. And they need a government that is effectively enforcing consumer protection laws that are on the books. And when I was in the state of Maryland, we did our level best to regulate the universe of people and entities that we had the authority to regulate. But it was a small subset of the universe of lenders. And my big into loans that they shouldn't have gotten into to begin with. And that's also a part of the analysis. But I have looked at the data, and I guess respectfully, I've studied the issue about it's the fault of the Community Reinvestment Act, and I welcome a further dialogue on that. I haven't seen evidence that came up today, and there was a researcher who was citing a rather robust evidence base to the contrary, and I've been rather dubious about that hypothesis, and I can't think of a context more than this context where we see, if there's a lesson above anything that we've learned, it's that consumer protection and safety and soundness go hand in hand. And the reforms that we helped usher in the state of Maryland, one of the noteworthy things about them is, number one, they were really aggressive, and number two, they were developed and ended up being voted on almost unanimously. And we had the mortgage bankers, the mortgage brokers, we had the entire industry at the table because they recognized that, the wild, wild west doesn't work for them. And so I think that's one of the biggest lessons of this crisis. And I don't mean to create a misimpression that if we enforce discrimination laws, we're going to solve this crisis. That is la-la land. But that's a big part of what we need to do. And that's the lever we have. And so that's the lever we will use. And I think we can make a big difference when we use that lever effectively. Yes, sir?
To go back to education for a second, it seems like part of the civil rights issue in education has to do with how a lot of schools are partially funded by property taxes or by local taxes. And I was wondering what your division, if anything, can do to challenge that practice, and if so, what have you done?
Yeah, that's a really good question. And we actually have been involved in the past in the state of Pennsylvania is an example of a case that we filed an amicus brief in. There was a lawsuit that challenged the funding formula at a state level of using the property taxes under a, bless you, bless all of you, by the way, I don't want to pick on you, under a Title VI disparate impact theory. And where the evidence supports that, we can potentially go down that road. A bigger challenge, or an equally important challenge, is the link between segregation of our schools and the segregation of our communities. If we can desegregate our communities, we can desegregate our schools, given the prevalence of neighborhood schools. And so we spend a lot of time trying to draw those links. And we have a housing section and we have an education section, and we spend a lot of time bringing them together because if we can encourage the integration of our communities, we can have, I think, a very important ancillary benefit of integrating our schools. My kids go to schools that are remarkably integrated, and integrated in every sense of the word. They're racially integrated. My kids have, I've got 3 kids. They've got, some friends have 2 moms, some kids have 2 dads, some kids have a mom and a dad. And it's just remarkable to me when I watch my kids interact. This is just the world they live in. And they have no other expectation. And that, I think, is what we're trying to get at. They have friends who are Latino, they have friends who are African American, they have friends who are white. It's really, I think, the ideal of what we're hoping. And regrettably, we continue to live in all too many communities in a persistently segregated environment. And that just creates a host of challenges as we move forward. And that is, you look at the data in the Grutter case, and the data was pretty overwhelming. Something like an ungodly high percentage of kids entering University of Michigan undergrad had no meaningful contact prior to University of Michigan undergrad with people who look different than them. And that's troubling. That's troubling on a number of levels. And so you ask a good question, and there's a number of challenges that your question brings to bear. One more question. You got the last word, my friend. Wait, you're Georgetown, but you're at University of Chicago. Okay, that's cool. Okay.
Thank you so much for coming.
My pleasure.
We heard a lot, I guess, during the Bush administration that basically the Civil Rights Division was, for all purposes, dead. And so I'm curious the kind of challenges you face, or that you continue to face, in trying to rebrand the Office of Civil Rights and to sort of spread this new mission, a revival of sorts, throughout the nation. To get this agenda moving forward.
The Civil Rights Division during those 8 years had some remarkable challenges. They are documented. Some of them are documented in a Inspector General report. I entered the Civil Rights Division in 1989. I was hired by President Bush, the elder Bush. I am just as proud of my service in the Bush years as I was as a civil servant in the Clinton years. And one of the real tragedies to me was that the Civil Rights Division I left bore little resemblance to the Civil Rights Division I came back to. And some basic systems were bastardized. The hiring process was hijacked. It became ideologically based. Communication with advocates, external stakeholders, was forbidden. Communication between people in the appellate section and people in the section that litigated the case at the trial level was forbidden. That one is a head shaker. And so our restoration and transformation agenda started with restoring trust between the career staff and the non-career staff, restoring public confidence, empowering attorneys by getting rid of a host of new bureaucratic obstacles. Let lawyers be lawyers, not memo writers. And I think we've accomplished a lot of that. We were hiring 102 new people. And if you want to know the process, go on our website, because we have a number of written policies about our career hiring. And those policies were written by career people for career people. And so we've returned that. There were people like yourselves who interviewed for jobs at the Justice Department a few years back and weren't hired for ideological reasons. And that's a fact. That's documented in the Inspector General report. And I don't care who you voted for the president. I don't care what party you are. I don't care who you worship, if you worship anyone. What I care about is, do you have fire in the belly for civil rights? Do you have a record of accomplishment? And can you do the job? And so we've returned to our roots, which is, let's hire the most qualified people. That's what John Dunn, the Republican appointee, told us to do, and I served on the hiring committee under him. That's what Deval Patrick told us to do, and that's what Tom Perez has told people to do. So we're making progress. We've still got some work to do, but I'm chronically optimistic. And we've picked up the pace of our enforcement across the board. Not only the quantity, but the quality of cases. A lot of impact cases. The AIG case, we're helping 2,500 people. The institutions cases, we're helping some of the most vulnerable people in America. We've stepped up hate crimes enforcement. We've really stepped up enforcement across the board. So the bad news is it was a lean 8 years. The good news is that civil rights is about resilience. It's about getting kicked in the gut, falling to the ground, and getting up with your pride intact and your resolve as strong as ever. And that's what we're doing. Great. Thank you for your time, Dean.